Yeah, very good morning to you all. Nice to see you again. As Colin said, I'm going to be talking to you this morning about discrimination. In particular, paying attention to two quite well publicised cases that many of you in the room will know, but have perhaps been a little bit misreported in the press. So I want to get to grips with the real position in those two cases and then tell you how we can minimise the risk of facing a claim for discrimination. So what is discrimination? Let's refresh ourselves. Well, the discrimination laws have been in effect for a long time, but they were codified or unified in 2010 under the Equality Act. No surprises that the purpose of discrimination laws is to promote equality within an employment setting amongst the workforce, amongst employees. And the way that it does that is it makes it unlawful to discriminate against a person or a group, a set of people, based on one of a number of what we call protected characteristics. Well, what are those? Sex, race, and by race we mean ethnicity, nationality, and colour, disability, sexual orientation, religion, age, gender reassignment, or pregnancy. So to fall foul of the Equality Act, fall foul of the discrimination laws, there's basically four ways that can be done, or four risks. Firstly, we've got direct discrimination. And this is where an employer treats an employee less favourably than it treats or would treat another person in the same or similar circumstances directly because of one of those protected characteristics that we've just seen. So a rudimentary example of this would be if you decide to recruit a new member of staff, you have a male applicant and a female applicant, they have exactly the same credentials, but you base your decision to hire on the grounds of gender. You want to ensure that you employ the female, that's your motivation. That is unlawful, full stop. Contrast that to indirect discrimination. Now this is slightly more blurry around the edges, and therefore the bulk of the litigated cases on discrimination centre around this area. It's where an employer applies an apparently neutral provision, criterion or practice, so a PCP, that puts those of the employee's protected group, okay, male, female, Christian, at a disadvantage compared with other groups. And crucially, the employer cannot justify that action. Okay, so that all sounds a bit garbled. I'll try and debunk that with reference to an analogy. When I was 13 or 14, under strict order of my mother, I was told to get a Saturday job, and in the local paper there was an advertisement for a laundrette who wanted a Saturday pair of hands. So I wandered down the high street, knocked on the door, and two nice old ladies said, "Can we help you?" I said, "I'm here about the job." And instantly they said, "Well, I'm very sorry, Lloyd, but we only have a female toilet on site. So good luck to you on your merry way." So was that action directly discriminatory, indirectly discriminatory, or both? Let's examine that. Going back to the direct, if I was minded to litigate against the laundrette and I pleaded direct discrimination, yeah, Burnham Observer, 14-year-old boy sues local laundrette. Have they treated me less favourably than they would have if I was a female? And I would argue yes. And if I made that out, it doesn't matter about justification, it's simply unlawful. If I pleaded indirect discrimination, I would say your PCP of having a unisex toilet has placed me as a group, a male, at a disadvantage compared with other groups, female. And we've made that out, certainly. So my claim would stand or fall on whether the laundrette could justify that action, that PCP. And the test is it a legitimate aim, and have you adopted a proportionate means to get there? So the legitimacy of the aim, I think I would leave that alone if I was pleading. I would argue this as a claimant on proportionality grounds. Why is it a female toilet only? Surely it can be classified as a unisex toilet. There's a pub 10 yards over the road. Can I use their facilities on a Saturday afternoon? If I was advising the laundrette as their employment lawyer, I would say, you need to dress this up very, very differently and think of another reason why I should have been rejected for the role. I hope that's made the distinction between direct and indirect clear. I just want to touch on the third and fourth ways you can fall foul of the Equality Act. Harassment is where an employer engages in unwanted conduct related to one of those protected characteristics that we spoke of. And the purpose or effect, so note intentionally or unintentionally, being to violate that employee's dignity or create an intimidating, hostile, degrading or offensive environment. I don't want to dwell on that too much. It kind of speaks for itself and it's quite a wide definition. Lastly, victimisation. This is victimisation not as we probably colloquially understand it, but for the purposes of the Act. It's where an employer subjects an employee to a detriment, again, quite a widely drafted word there, because he or she brought or is going to bring proceedings under the Equality Act. So an employee brings a claim for direct or indirect discrimination and is then subjected to a detriment as a consequence of so doing. That adds another string to the bow in the claim, or if it comes at a later date, gives rise to a fresh claim. The first case I want to talk to you about is UADA and British Airways. This is a very widely publicised case, and I've made an attempt at a humorous pun. Hopefully the humour will arise as we go through the facts. Forgive me if not. Nadia UADA worked on the check-in desk at Heathrow Airport, and she is a lady of strong Christian faith. And she wanted to wear the cross on a necklace on the outside of her uniform during the working day. This was contrary to British Airways' uniform policy, which was broadly stated, no jewellery to be worn visible on display to the members of the public, save for artefacts of mandatory religious scripture. Okay? And when they compelled Nadia UADA to hide this necklace, she refused to do so. She was suspended. Long story short, she brought a claim for discrimination against British Airways, saying that she had been treated less favourably on the grounds of her religion. Okay? That claim failed in the Employment Tribunal. She appealed. It failed in the Employment Appeals Tribunal. She appealed again to the Court of Appeal, and the Court of Appeal ruled or upheld the two lower court decisions and found in favour of British Airways. Okay? And they said that, well, if we go back to the definition of indirect discrimination, has she been put at a disadvantage as part of a group? And the Court of Appeal heard evidence from practising Christians and found that there was no less favourable treatment here, and in any event, it could probably be justified applying that test of proportionality and legitimacy. So BA succeeded in the United Kingdom, but the reason why it's been reported recently is she took it up to the European Court of Human Rights in Strasbourg and claimed that the United Kingdom, the Court of Appeal, had failed to protect her what's called an Article 9 right under the European Convention of Human Rights to manifest religious expression. So the finding was turned over on a claim on application to the European Court of Human Rights. I don't want to drill down into that too much, or even at all actually, but just to say that where we're talking about religion, employers need to be very careful when drafting policies, for example, uniform policies, or if you widen that to accommodate religious expression within your workforce. It's quite a strict test now, as this case has shown. I'm going to contrast that case with Barr and the London Borough of Merton. This is a rather sensationalist headline that the Daily Telegraph ran. Christians have no right to refuse work on Sundays. That's a bit misleading, and we'll explain why. We'll see why shortly. So Ms. Barr was a very qualified childcare supervisor, and she got a job working at a daycare centre, specialist daycare centre in, the London Borough of Merton. In her contract, it stated that she was on a rota system and could work on any of the 7 days, but she had a conversation with her supervisors, and it was understood that every effort would be made to accommodate her request not to work on the Sunday. and respect the Sabbath. And for the first 2 years of her employment, she was accommodated in that way. She didn't work a Sunday for around about 2 years. But of course, as they do in the world of work, circumstances changed. And London Borough of Merton asked or put Miss Barr on the rota for a Sunday. And she wasn't having any of that. She said, I'm not coming in. She was subject to disciplinary proceedings for that and walked out of the door after being given a final written warning. She brought a claim against the London Borough saying that she had been discriminated against indirectly because of her religion. Her claim failed. Her claim failed in the Employment Tribunal and it failed on appeal, and she hasn't, as yet, at least, brought it up to Europe. So let's go back to the definition. The PCP here was putting her on rota for the Sunday. Was she put at a disadvantage as a practicing Christian compared with other groups? Potentially, yes. But this case turned on the justification test. And the Employment Appeal Tribunal found, that the London Borough of Merton had made every effort to accommodate her. They had allowed her to attend church on those Sundays, even when she was on rota. And ultimately, they said that the balance to be applied was, well, we have the same rota system for all of our staff here. And that was found to be the legitimate aim, and it was found to have been proportionately implemented. So her claim failed. So perhaps this headline should read, Christians have no right to refuse work on Sundays when they're contractually required to do so in their employment contract and where their employer has been proportionate and legitimate in accommodating requests to express faith through religion. So, what are the risks of a discrimination claim against your business? Well, discrimination and unfair dismissal are collectively by far the most common claims brought against employers. With unfair dismissal, the compensation is subject to a cap, currently $72,400, I believe. But a claim for discrimination is uncapped, and this is where the big money claims are, certainly in the city. You get huge awards for falling foul of the Equality Act. And just as importantly as that, they can arise without us really knowing. We can go about our daily business, applying managerial decisions, hiring, firing, writing a policy. That can, without you knowing or giving much thought to it, cause someone to believe they've been discriminated against. And then you're facing a claim which, as we've seen from the case law, could amount to trouble. Particularly vulnerable areas are where you're recruiting new staff or promoting within an organisation, where you've got policies for working hours and time off. Typically it would be, you would potentially, if you're operating a rigid structure on your working hours, you could be indirectly discriminating against the female portion of your work staff. We've seen from the British Airways case, dress and appearance policies can lead to indirect discrimination claims being brought, failing in the UK and then succeeding in Europe. So it's all a bit of a minefield. So what can we do? What's the answer to minimise these risks? Well, having strong, clear, top-down policies. We as organisation X, Y and Z operate an anti-discrimination policy, and these are our objectives, these are our motivations. That's going to protect you on the legitimate aims part of the test for indirect discrimination. Drill those down in an employment handbook, which is widely available to all members of the organisation. Offer training, maybe a biannual training seminar on this stuff to your middle management, those people that hire and fire. Have a clear and effective complaints procedure, to stop these matters from getting to the tribunal door. And be accommodating and flexible. We live in a society of different cultures and beliefs. That's wonderful. Let's do what we can as employers to accommodate that, and indeed having a flexible working day may actually be of benefit to your business commercially, as well as protecting against potential discrimination cases.